Thank you. Good morning, you guys. Thanks for being on time. It's really my pleasure today to introduce our speaker, Tracy Kayser. She's been a great resource to myself and my clients and our company. And I think you guys are really going to get a lot out of today's course. So, a little bit about Tracy. She was a former real estate agent, so she gets it. She gets where you guys are at. She was also a law clerk for over 40 years and an LA estate planning attorney for 2 years. She started her firm in 2010, and her current practice is estate planning, business succession, trust administration, probate administration, conservatorship, guardianship, landlord and tenant, and real estate matters. And again, she's been a great resource for myself, and I think she'll be a great resource for you. So I'm going to hand it over to Tracy. Thank you, Tracy.
Great. Thanks, Michelle. I'm just wondering, can you guys hear me? Want to make sure we're all heard? Okay, let's do this. So thank you for having me, first of all. And we have quite a few things to talk about. This presentation is a little bit fast and furious because what I mean by that is it's not really on topic to one issue. What I'm going to be doing is talking about kind of a number of different issues that we deal with in real estate, and that we deal with in probate court. So most of my probates, believe it or not, come from realtors. I'm a probate. I love probate. I have about 100 of them. I work them all over the state of California. And the people who seem to bring me the most probates or the most business is real estate agents. And I was a realtor. I'm still a broker, but I was a realtor for 10 years before I went into law school. And then now I deal with mostly real estate stuff and probates and estate planning. And it all again touches real estate. So that's what I love it. I'm happy to be here and talk to a bunch of real estate agents who are my kin. So this course is a quickie. It's a short course to help you obtain a general overview of the probate process and Prop 19. It's a short course to help you obtain a general overview of the probate process. Just a little blurb on Prop 19, Assembly Bill 2016, Assembly Bill 2024. Realtors are integral in their clients' matters as they sell real property as an asset of an estate. All of these codes, and the probate code affects real estate and touches real estate a lot. So the first thing I'm going to talk about is probate, and then we'll go into some other things. First of all, the big question is from some real estate agents, more sophisticated real estate agents, and don't ask this, but why do I have to be in probate? I've had a lot of experience with realtors where you get a listing, you're moving the listing along, you go into escrow, and all of a sudden you realize, oh my goodness, the grant deed is there's something wrong with the grant deed. There's either a tenants in common issue, there's multiple owners on a deed, we have somebody that passed away, and we're not able to close escrow. We have to get a probate. So title companies a lot of times will also have me do work for them to try to clean up the deeds or clean up probate. So a frequent question, why do I have to do probate? It's a title clearing process. And here's something interesting we're going to go through a little bit further down. But in California, when you die without a living trust, your heirs or beneficiaries will have to engage the probate court to transfer the title out of your name into their heirs. Now, the threshold now, today, as of April 1st, is $750,000. That is huge. That is like headlines because it was only on March 31st or March 30th, if we had only a 30th, um, it was 184,500. So almost every home in California had to be probated. Now today, the law has changed, and if a home is valued at under $750,000, you are not going to be able to, you're not going to have to do a full-blown probate. We're going to go into that a little further down the line. Let me go further. Responsibilities of a person, and the realtor works with the executors, or when you're an executor, it means you have a will. When you're an administrator, it means there's no will or no trust. But what a person does when they're an executor or an administrator of an estate is they and this has to do with the real estate, is they have to gather the assets. They have to also usually, like right now, I have properties where everyone's locking down the properties. They're gathering assets. If they have tenants, they collect rent. And these are usually family members who've become the successors of the person that passed away who owns the home. Their responsibility when they go into probate is to marshal the assets. It doesn't have to be just cash accounts or investments or stocks. It's going to be real estate. And when it's the real estate, they have to make sure that the real estate is protected. For some reason, the last couple of years, well, we know a little bit why, but there's been a lot of squatters, a lot of homeless people taking over properties. I have a lot of stories. One case in particular I'll tell you about real quick is a San Bernardino case that I have right now. We just closed escrow. It took over 2 years to close escrow because the individuals who moved into the property were squatters and they claimed to be heirs of the estate. So what they did was they filed appellate paperwork in the Superior Court, which then froze the probate from moving forward. And we ended up having to search for go through 4 title companies before a title company would take the risk and help us figure out and unpack how to close escrow. It was crazy. And we had to sell the property with the squatters in the property. We could not sell it without moving them because they were actually dangerous people. Really interesting stuff. Um, when you as a realtor hire a lawyer to engage these processes, one of the things that you're going to do is the realtor is going to, or the attorney is going to file a petition for probate. They're going to file a notice of hearing. They're going to have the client fill out duties and liabilities. These are all the documents you have to fill out when you do a probate. The one of the things that's going to be relevant to real estate agents are the 2 forms that you guys have to do, which is a probate, usually probate listing addendum and advisory, or a probate purchase agreement, which is called a PAPA. So I have quite a few realtors who sell they're certified specialists, they sell properties. You're going to make an offer on a PAPA, not just a regular car RPA form. And in the old days, realtors they would use the RPA, and when it had to do with selling property in court, because sometimes when you have a probate, you get 2 choices. You get to choose to sell the property without court approval, without court confirmation. But sometimes the court says, Tracy, I want you to come into court and I want you to use limited authority. You get limited authority without me approving this probate sale. I never, ever, I beg the judge, I never get limited authority. I always get full authority because I want my realtors to go through the regular escrow process and title process without using the courts. However, if we have family members who are litigating or their problems, we will have to go into court and get court confirmation. So this PAPA or this PLA, the probate listing addendum and advisory will say that a court confirmation may be required, and that gives notice to the buyers that we may have to go to court. And that's something that's a part of some of these cases. Now, usually when you're a selling agent, usually the buying agent's going to bring an offer and they're going to say, does this require court confirmation? And the listing agent will be able to say, yes, it does, or no, it doesn't. Okay. What is the difference between, I just explained this, what is the difference between Independent Administration Estates Act and versus court approval? It's called IAEA versus court approval. I, as a probate lawyer, seek full authority. I don't try to get court approval because what happens is it requires court confirmation. I have to publish in the newspaper for 3 weeks. I have to do an application to the court to get approved. I have to go to court, and then there's overbidding. So let's say you're the buyer's agent, or maybe you flip homes and you make an offer on the property, the offer's accepted. You may not be the ultimate individual who gets to sell that home if we have court confirmation, because if you have overbidders in court, and I've had them, I've had them, you may not be the individual or the realtor that gets to sell that property. So we try to do full authority, which keeps you out of court from having to do that. When you sell a piece of property in probate, and for some reason in the last couple of years, I had a lot of individuals who have used our services and they are home flippers. So they have learned this system of going to look for foreclosures, and then they make offers to the sellers. And what they do is they're looking to discount the property if the property is in bad condition at maybe $100,000 less. It's a bit of an issue when it comes to me because I'm the attorney that has to respond to the judge. Why is the home fair market valued at maybe 400,000, but you sold it for two? I'm in trouble, or the administrator's in trouble. I have two cases like that. I'm going to have to get past the smell test with the court. I don't know what I'm going to do, but I'll figure it out. And there's a 90% rule in probate. You cannot sell a property less than 90% of the value. So if a property is worth 100,000, you may not sell it for less than $90,000. That is not a good combination usually for home flippers right now, because what they want to do is they want to buy it at a discounted rate, and then they want to sell it for a much higher rate. What I do as the probate attorney is I have to justify to the court through pictures, through explanation, the devalued value of the property and why it's not in the condition, why it didn't sell for what would be considered fair market value of the area. Usually the property's in disrepair, and we have to try to prove that. So that's part of my job when I'm working in a probate. When you are selling a home and you're in the middle of the probate process, and also in trust administrations, let's say you guys represent a home where or represent a seller where the property's in a trust, not a probate. Okay, trusts will keep you out of probate. You still have to do what's called a notice of proposed action. A notice of proposed action is a document that gets filed with the court, or it gets served with the beneficiaries of the estate, saying, hey, you are heirs to the estate, or you are beneficiaries to the estate, and I'm proposing to take this action in 2 weeks from now. My proposition is that I'm selling the property for $1 million, and if you object to it, you need to put a check in the box and send it to me. Otherwise, after 2 weeks, I will you will have been deemed to have approved the notice of proposed action. In other words, I'm going to take the action. Now, when it's a trust, usually we're still not in court. We have to deal with the family members to make sure we can maybe have a group meeting and figure out why somebody's objecting. We can go to court to get confirmation, but in a probate, if you have full authority in a probate and somebody objects, guess what? It throws us into the court system. I have to do a court ordered sale. So I've got to actually have the court do the sale or approve the sale, not me. How are creditors in probates handled? When people pass away, they have debt, and I have a lot of it. We have had a case where there was a home in Seal Beach worth about $1.2 million, and there was debt on it of close to probably $1.2 million. And what happened was we were able to hold off the creditors and to negotiate the debt on the creditors to at least give the heirs about $200,000 of equity when we closed escrow. But creditors have to be paid in the probate. And they're not credit cards usually I'm not worried about. I can usually work with those, but it's other types of creditors that we have to deal with. Sometimes when you walk into a probate, you don't know that the person was on Medi-Cal, and Medi-Cal always has recovery in probate, or you don't know if they've had hospital bills or judgments against them. And those are the things that we have to deal with through a preliminary title report. And also the realtor has to deal with them as we go through the probate process. Let me switch through that. The difference, so that was probate. The differences between probate and a living trust, and I apologize, guys, I'm going to go quick because I'm going to talk about these new laws. Even though in California now we can sell a home without having to go through probate at 750,000 and under, you're still going to go through a small probate process. The better option always, always, always is to have a living trust. I prefer it over a transfer on death deed. I prefer it over joint tenancy. I prefer it over tenants in common. If you can put the property in a trust and you can have your clients do that as you're selling them property, they will avoid not only capital gains, but their children, the people who inherit the property, will receive what's called a step up in basis to the value of the property. And that's what you're looking for, because sometimes these trusts are done 30 years ago and the homes have been bought for 100 grand and now maybe it's worth a million. Well, guess what? Those children inherit that property at a million, which is a zero basis versus $100,000. And so a living trust is always going to be better than having a probate. If your client left a will, and by the way, in California, you cannot do a will, you'll be in probate. You must use a living trust. Let's say there's a home that's worth $600,000 and they don't have a living trust. The estate's going to pay approximately $33,000 in probate fees, and it's going to take approximately 12 months, really not 9. We try to hope for 9 these days, but 9 months in probate court to transfer the house into the daughter's name or to transfer the house and get it sold. Um, that those fees could be avoided by having a living trust. You avoid court, you avoid the probate process completely. My fees for a probate, the attorney and the administrator make fees of approximately, well, it depends. A $300,000 home, it's usually about $15,000 per person, but the fee structure is this. If you're going to sell it, if you're going to be in probate court, the attorney receives a statutory fee based upon the value of the real estate, and it's not an hourly fee. Otherwise, we people wouldn't be able to afford attorneys. So the statutory fee says you're gonna you're gonna Tracy, you're gonna get paid 4% of the first $100,000 of the value of the estate, and then you're going to get paid 3% of the next 100,000, and then 2% of the next 800,000. Now, most of the time in my world, we're looking at maybe a $15,000 fee, $20,000 fee, but that's after a year's worth of work. There have been cases where my fees have been $80,000, and one time it was about $380,000 for one probate because the estate was worth about $60 million. The individual did not do a trust, so those fees can get pretty hefty. Again, the laws have changed, and we're going to talk a little bit about that. Proposition 19, I think you guys have been probably living with this now for a couple of years. The current law allows for the personal residence of a individual to be distributed to a child without reassessment, regardless of the value of the residence. But that was the old law. The old law was Prop 58, and the old law said, Trace, if you have a client who has 10 properties, they died and they own 10 properties, your kids get all 10 properties under Prop 58, no reassessment. Gone are those days. The Howard Jarvis Taxpayers Association has tried to repeal Prop 19, and we've not had luck. We don't think it's going to happen. And I will tell you, it's upsetting because I don't want to blame Carr, but Carr was a part of this process. I don't think they thought the whole thing through. Prop 19 was passed on November 3rd, 2020, and it limits the ability of parents to leave real estate to their children without a reassessment of property taxes. Prop 19 was marketed as a provision to benefit homeowners who are over 55, the disabled, wildfire, and disaster victims. It really was touted as a wildfire recovery, where California said, okay, I want to help the people victims of wildfires. That wasn't really the problem. The problem is now it is a it is a death tax, is what it is. So the proponents said that it would fix a loophole that permits wealthy persons and celebrities from leaving their residence to their wealthy children. Guess what? Beverly Hills residences, if you have a lot of money and you inherit a property, maybe you're okay. But a lot of homes in the hills, Los Angeles, are they're heirloom homes where mom and dad could afford that home back in 1930, 1940, 1970. The children don't do as well as mom and dad. And when they inherit that property, if they don't live there, property taxes go sky high. That child has to make a decision. Either they move into the property or they have to sell the property because usually you can't afford the property taxes. So it's changed everything. The proposition contains significant property tax increases that are borne by the children and grandchildren who receive real property from parents and grandparents. It affects not just the wealthy, but all families. It affects everybody. So people have to sell more, and maybe that was part of the point. But the only way you can avoid a Proposition 19 reassessment or special tax, I guess, it's not really a special tax, it's going to be an increase in property taxes. You have to live in the home and you have to file within 1 year. Now, even if you file that and you meet all those requirements, If the property is worth over $1 million or worth a certain amount of money, there still may be a slight bump up in their reassessment because they're still not going to give you a full freebie. So that's all I'm going to be able to talk about on that. But I don't I don't love Prop 19. I don't think most of us do. Title issues, other types of court filings. Again, I'm going quick, guys, but let me just give you the kind of in the real estate world, what we deal with is we deal with probate, we deal with trust administrations, we deal with the Prop 19 issues. The other thing we deal with is what are called Hegstad petitions. I get a lot of agents coming to me asking me, Tracy, there's a trust, but the home isn't in the trust. How can I fix this? Do I have to go through probate? And I say usually no. If there's a schedule on the back of on the end of the trust, or there's an assignment of that asset into the trust by a separate document, I can use the estate of Hegstead and I can file a petition with the court that says, Dear Judge, I would like you to pour this asset into the trust because the trust has already identified the asset on Schedule A to be an asset of the trust. I should not have to go through a full probate. Please approve my Hegstad. And I'm 100% of 100 so far. We get them always approved. I think it's because the court wants these properties not to be in probate. They want to get them out of their the judges don't want them to be in their case files because now they're dealing with thousands of files, hundreds of files. I think their files will get a lot slower now because our threshold is 750,000, not 180, not 184, 500. But they want to approve Hegstads because they want the family members to receive the assets from the trust. The other thing is if we can pour the asset in the trust, we've got to step up in basis to the heirs. That's a huge deal. So it's called a Hegstad petition, and it has to do with a revocable living trust and essentially pouring the asset back into the trust, which is the real estate. Oh, it can be any asset. It can be a 401k. I've done a 401k. Partition actions. I have a couple of those right now. A partition action is again when dealing with a home, let's say, where mom and dad, they own the property, no problem. They distribute the asset out to the children, and the children, instead of selling the property, maybe they put it in their name. So let's say John and Jane, they have the property put in their name as tenants in common or joint tenants. And then all of a sudden Jane wants to sell and John doesn't. They have to hire a lawyer to file what's called a partition action, because if one person has ownership of a property and the other one wants to sell and the other one won't sell, the only remedy you really have is to go to court to force the sale of the property. When you file a partition, the judge is always going to sell the property. He's always going to force the sale of the property because he doesn't really want homeowners owning jointly if they don't want to own jointly. The only thing is that they're going to be dealing with is having to hire a probate referee, or not a probate, but a referee. The referee will hire a realtor, and those assets will be distributed pursuant to the referee. It's not just an equal split. It's going to be having to be put in an account, the assets accounted for, accounting to the court, and maybe even the money's distributed unequally because maybe one family member paid more than the other towards property taxes and mortgages. So that's called a partition action. I get hired to do those as well. Quiet title actions, we do those as well. Quiet title, again, back to real estate. That's what this whole course is about. There's a lot of times where you have what are called clouds on title, where the title company will go to the attorney and say, Tracy, I can't really close escrow on this because I have a property that is got a cloud, meaning that, or I have a property where there's 10 owners on title as opposed to just mom and dad on title. And what's happened is in 2008, I think in 2013, whenever we had those big foreclosure issues, and we're having them right now, guys, my board I stopped 5 foreclosures this week. And that's well, at least in the month of April. This week we've stopped 2 or 3 of them, but we have a ton of restraining orders we're filing because we have to stop foreclosures. And a quiet title action, sometimes what people have done is they've hired individuals to cloud the deeds. They file all these crazy deeds, and the lender or the trustee for the lender can't close because they don't know who those individuals are. If those individuals have a legitimate claim to the property, and so all of a sudden they're frozen, and so the foreclosure sale may go away, but now the person can't sell the property, and so we file what's called a quiet title action, and we go to court, and it takes about 8 months to it could take a year. We go to court, and we actually have to file this paperwork with the court and ask the court to clean the title and to remove all those individuals off of those deeds. I have about 3 or 4 of them. I just finished one. It took about 2 years because of the court system. The court took a long time to get things done. This is in civil court. This is not probate court. I usually don't file quiet titles. I've never filed in probate, but we file in civil court to clean title. Okay, new law, AB 2016. This is the new law that's been the most dynamic, I think, for us as probate lawyers. I think for me, I was a little worried about my own business. You know, what am I going to do not getting probates? But I think a lot of homes are worth more than $750,000, so we keep plugging forward. If a home is worth less than $750,000, and there's plenty of them, the heir to the estate can file what's called a petition to determine it's called a petition to determine succession to real property. It's still a probate filing, but they don't have to do a full-blown probate. So if the property is valued at less than 750, you can get the probate property value by what's called a certified probate referee, a certified appraiser. You fill out the paperwork. You give notice to the families. So you got to give notice to all heirs. The heirs have to be notified of the filing. You file this petition with the court, petition to determine succession, and that gets approved maybe in a couple of months, and then the property gets distributed to the heirs. So what's happening is, I'll read through this a little bit for you guys. AB 2016 raised the probate threshold from instead of 184,500, it went to 750. It applies only to the decedent's primary residence. So you can only file. So if your mom and dad only own a primary home, you should be good to go. If you're a single child, you should be good to go. If you have multiple family members and you don't get along, I don't care. You have to give them notice. So it applies to the primary residence and comes with new requirements that could complicate things. I think there's going to be more litigation now than there might be some probates, because if family members don't get along and they don't give notice, we're going to be in court with a different type of petition telling the court that the family member who filed the petition did not give notice to the other heirs, or they've left the beneficiaries or the heirs out completely because they're trying to gain access to the property. So the requirements of this new law says you have to wait 40 days after death. You have to make sure that you're eligible to comply with these rules, and the eligibility is only primary residence. If you have two homes, or more, or you have other assets that are over the 184,500 threshold, you have to be in regular probate court. You're not going to be able just to do the AB 2016. You have to notify all interested parties. You have to file the petition to determine succession. You attend the hearing and you record the order. You get it recorded in the county recorder's office. Again, seems simple. It probably is, and it's going to be great. But I have a feeling what's going to happen is family members who don't want to give notice to their siblings because they don't get along, or they don't know where they are, or they don't. I mean, heirship companies are going to be finding heirs. It's going to be a whole new world of court filings that are going to be a little bit different. That's the new law. AB 2016 took place April 1st, 2025. And what you should be doing is you should be familiarizing yourself with that, because you will be able to help your homeowner not go to probate court. You just need to hire a lawyer to do the petition to determine succession, which should not cost as much as a probate. Last one. And this is a great one, you guys. You need to know this law. It's Assembly Bill 2424. The actual civil code is 2924. And the Assembly Bill was 2424, but the California, I guess it got codified in the Civil Code of 2924. When I have a property that's going into foreclosure, and I have one right now that I've used, and I have a sale that's coming up that's more than 5 business days away, if I have taken a listing on the property, or if I have a sale on the property, I can serve on the trustee. I have to serve them with a packet of information. I have to send them an overnight certified copy, so it goes overnight to the trustee to their address. I can hold off the sale for 45 days. It's an automatic um, kind of freezing of this foreclosure sale, and the trustee must honor that. But you have to make sure you follow the requirements. It's for 4 units or less, and then the mortgagor will be stopped from foreclosing, and the trustee will be given notice. The trustee has to tell the mortgagor or the lender that you get 45 days to get that property sold. And then guess what? You you present a listing agreement. It's a legit listing agreement. You show Civil Code 2924. You show the listing agreement and you overnight that. They give you 45 days. When you are in and when you're in escrow and you get a purchase contract and RPA, you can do another request serving the purchase contract and you get another 45 days. So we are going to avoid a ton of foreclosures or temporary restraining orders by using this code and using this AB 2424 to tell the lenders and the trustees you cannot foreclose because I'm allowed 90 more days to get the property sold, and it's going to save people a lot of money. So just put that in the back of your mind when you have a foreclosure or a trustee sale coming up. If you can do a listing on that property quickly, and that might help you, and you can get this sent to the trustee 5 business days. It can't be 4. It has to be 5 business days. So you have to start on day 6 or day 7 and get that overnighted to the trustee, and then you have to email it to the trustee. You should be able to get 45 extra days. Okay? I think that might be it. And that's what I used to look like before children. So that's that's my presentation.
That's awesome. Tracy, can you take some questions if anyone
I
has a
sure
question?
I sure can. And I'm going to apologize to everybody because that's fast and furious, but that was the whole point. Michelle asked me to kind of cover a bunch of topics, so I did.
Yeah, so thank you. No, that was great. I was taking great notes and really appreciate your presentation.
Sure.
If anyone wants to unmute themselves and ask Tracy a question and take advantage if we have a little time, please do.
Hi,
Hello, can you hear me?
I can.
Hi, Tracy. Nice to meet you. Thank you for
Nice to
the
meet you.
great presentation.
Thank you.
I was not aware of this, and this is impressive. So you're saying that if you don't have the living trust, you don't get the step-up basis?
Well, you will get a step-up basis if you're in probate. No, you will. If you are California, so if you're going to go through probate, the California Probate Code creates a will through its code to the heirs. When a person passes away, there will still be a step up in basis to the heirs. They will inherit the property at that new step up. But a living trust kind of helps avoid the probate court. Either living trust or either probate, you're going to get a step up. Okay. However, a living trust avoids probate. It avoids the probate fees, and through either process, as long as you sell in the right time, you will avoid capital gains. It just depends on the circumstances and it's a case by case basis. But in
Okay.
probate, no, you're not going to pay capital gains just because you're in probate.
Okay, and that includes all other investment properties, as many properties that they own. If one of the two people, let's say husband and wife, one person dies and they have 10 properties, including the primary residence, all of them they get step up at that time, and if any of them sold, they will be no subject to no capital gain taxes. Is that correct?
Sep, I'm going to tell you I don't have a full answer on that. I know the primary residence will. It depends on, I believe, a number of factors, but I would want to say that they should get all a step up in basis because it's going from the parents to the children inherit the property. But what I'm always going to say is you're going to check with a CPA to make sure that that step up is there. Okay, and what we do is we file a tax return in every one of our estates and our trusts to make sure that there's no capital gains owed. So that's a question for a CPA still.
Okay, thank you so much.
Thank you, sir.
Okay, next question. Anyone have a question for Tracy?
That's okay if you don't. It's a lot.
I have a question, Tracy. Like,
Sure.
You can unmute yourself if you want to talk.
Well, I had my hand up, but either way,
go ahead.
my questions are fair market value on probate. So are there things that realtors can do? You had said that one of your biggest struggles is when investors are coming in and trying to buy a property below the 90% threshold on the appraisal. Are there things that the realtors can do as partners to help you with that process? Can they take photos? Can they go out and get quotes from contractors? I just closed on one that the bathroom in the house, one of the bathrooms in the house was not was completely covered in a black sticky substance that appeared to be mold, but since I'm not certified to be able to identify mold, it was unfinanceable, and so it had to be sold to a contractor.
Okay.
Or someone that could pay cash.
Got it.
So what can realtors do to help you through that process or to be appealing to a probate attorney?
So a probate referee is the person that we have to get that value past the probate referee. They send the inventory and appraisal to us and they give us that value. And I've had to, on a number of occasions, call them and say, I'm so sorry, this is not correct. May I send you photographs? Can I show you a contractor's estimate of repairs? And they will absolutely accept that because they don't want to be wrong. Now, I had a probate with a property in Malibu where the property was valued at $5 million and the probate referee valued it at $7 million. And I called her and I said, there is no way this property is worth $7 million. We are going to be at a $2 million gap. And so you want to talk about capital gains SEP or taxes, that would have been a taxable estate. And what I told the probate referee was she said to me, I know Malibu, I know what I'm talking about. And I said, I'm so sorry. It is not correct. And what ended up happening was we provided her, the property took a long time to sell and the property, we got an offer, it would fall out, got an offer, it would fall out. And so I had to show her multiple offers. And what ended up happening was it took a year and a half for her to be willing to give me an INA. She was upset. She was irritated that I was telling her her value was wrong. And I wasn't really, but I was saying, look, this is not correct. It's not worth $7 million. But what I did was I provided her the purchase contract and the closing statement. And I guess what I got? I got an INA at $5 million. Because ultimately they don't want to have problems. But they need to have justification.
Yeah, if I get 6 offers from different investors and they're all in the same ballpark, and I get 0 offers from a traditional buyer, are there other things that realtors can do to be effective and helpful with their probate attorneys? I work with a lot of probate attorneys, and are there things I could do to be better in my relationship with them?
I think you probably already do it. I think you need to pull a prelim and you need to check the prelim and you need to pull the deed history, not just the most recent deed. Because what I'm telling you is when I've done the deed history, I'm tracking what's happening from the very beginning to the current deed and seeing what's going on with the deed. I need those for my quiet titles. I need them for my partitions. Sometimes I need them for my probates, like my Hegstad petitions. But for a regular probate, I just want to see, I like the 30,000 foot up view. I like to look over everything and make sure I've got everything under control. So sometimes what happens is not probably you, Lee, but some realtors you get excited, you got a listing and you're not checking title and all of a sudden you realize title's clouded. So I would say that would be helpful. And then again, I mean, as long as the property is not in foreclosure, if you pull a prelim, you're going to know that there's going to be a notice of default on the property. That's my world right now. I'm stopping. I'm living in foreclosure hell right now, trying to stop foreclosures on my properties. But I think those two things, it sounds like you know what you're doing, and I'm sure the attorney appreciates your help. The photographs, the valuations are critical. If those are given to the attorneys early up, or at least when after letters are issued, super helpful for the inventory and appraisal. By the time the realtors get, I mean, really what happens is you guys are involved on day one, and hopefully by month 3, you're out of it. So what happens is the attorney, or month 4, let's say, because what happens is you file a petition for probate, and then what ends up happening is you get a hearing date usually 2 months later. That's what we hope for, because the probate code says you must, dear judge, you must hear this petition for probate within 2 months. It's a statutory requirement. We actually put it on our petitions. But what happens then is once that client gets approved and letters of administration are issued, you guys get to close escrow. If the attorney doesn't have the valuations and the pictures, they have to go back to the realtors 5 months later, 6 months later, and you guys have moved on in your life and your listings. So I think just having everything up front is great. Sound good?
That's perfect. I have
Okay.
another question, but I'll let someone
Sure.
else ask first. Not seeing any.
Go for it, Lee.
My next question, what's the cost of a living trust on average? If I have a sale right now where they're wanting to do tenants in common, he knows he's going to leave it to his kids. I want to have a better conversation with him on why he should look into trust options.
Okay. So tenants in common is a rough one, and I'll tell you why. Are they married?
No,
Partner?
he is a widow, and he's 93, and wants to sell his current place and buy a new place with his daughters in tenants in common. And what I'm suggesting is that he consider a trust to avoid probate.
So that's that has to go. That goes back to, I think, what Sepp was talking about, which is capital gains. When you're on title, so let's say he puts the property on title, himself and his kids as tenants in common. If he dies, guess what? Let's say he has 3 children, three individuals who own it as tenants in common. Let's say one passes away. That person that passes away, their 1/3 goes to probate. Okay, now we're at $750,000, so we're still now doing a smaller petition. But now the daughters have to hire an attorney, because they're not going to figure it out themselves usually, to file a petition with the court to get that approved. Then the other issue is let's say then dad's share goes to those 2 children, those 2 daughters, 50-50. So now we're 2 daughters, tenants in common. With tenants in common, you have the risk of now one of those kids dying. Same problem. Or they have their own blended families, or we have other issues. But if they choose to sell the property before they die, the date of acquisition and then the date of sale, you may have capital gains. Okay. If dad puts the property in a trust in his name and does not give it to the daughters, and he says, my daughters, I'm going to give as heirs, as beneficiaries of the estate, full step up, the daughters are automatic. It's guaranteed that they're, I mean, unless the trust is lost, which now attorneys have them, they have their trusts in the cloud, but the daughters will receive that property without court intervention, uh, full inheritance, no capital gains, unless they hold the property and then sell it later. That's their issue. But they get a full step up in basis and property taxes as well. Then, of course, they have to think about Prop 19, whether they're keeping it or selling it. But we really don't want co-ownership with a parent. It doesn't make sense, and especially these joint tenancy people and I love joint tenancy. I still like it. But when you have joint tenancy, you have the same problems where one person passes and yes, the property goes to the other joint tenant, but if that person chooses to sell, they've already been an owner, there's also going to be potentially a change in property taxes. Please excuse me. I'm sorry. Does that help a little bit?
Excellent. Yeah, that's very helpful. Thank you.
I ask a question.
Sure.
How much do you charge to put together a trust for someone?
Right, for a single person, it's about 3,500, and for a married couple, it's 45. I will tell you that if you're going into sophisticated estate planning with LLCs and the laws are changing in 2026, potentially, unless Congress passes potentially the new laws. I don't know what's going on with the laws, but there's a possibility that we're going to keep our estate death tax thresholds right now at over 14 million per spouse. If you don't, the sunset goes back to 6 million per spouse. So we may end up having to do different types of planning. And if the planning's more sophisticated, it could just be more expensive. It just depends on the estate. Simple estate, single family home, 2 homes, under $6 million, it should just be 35 and 45. The estate planning documents, whether it's me or another attorney, it shouldn't just be the trust. It should be a pour over will. The grant deeds should be taken care of. That a lot of attorneys don't do the deeds. They have to be done because otherwise you have an unfunded trust. And then you should have a power of attorney for assets and a power of attorney for health. You should have the whole package.
Yeah, that was my next question. Does that includes the whole full package? That's good to
It
know.
includes, yeah, for me, I'm the notary. I meet with the client. I explain it. It includes the binder. It includes the first property funding. If you have 10 properties, of course, I'm going to charge you per property because I have to pay for the recording. But for most people, it's a package deal and it works.
Ask you a silly question.
Sure.
How do you write on your board like that?
You know what? I didn't. The board was up, the board was not on the wall. And so I was using it standing up, and we are an office of boards. And so I finally had somebody to install it, and I haven't been able to erase it and fix it. So that's hilarious. Didn't even realize it was still sideways. So good question though.
I thought there is a,
No,
system
not at all.
for
It's
that,
just
right?
it was laying down forever. I just didn't get it on the wall. So thank you for asking though.
No worries. It's all good.
Tracy, you had said you had talked a little bit about Prop 19 and some of the cons that you see to that. Is that mostly in terms of the inheritance for the children that you see as being the most problematic? Because it seems to be valuable for transfers of living folks. Your concern is mostly around the inheritance.
There's a benefit that the one benefit of Prop 19 is you can take your property tax basis to different counties. So it's just a simple form to file with the recorder, and you should be able to get your basis transferred. People 55 and over with severe disabilities, because you have to define disability, and I think there's a couple of other exclusions to be able to get that benefit. So that it used to be only reciprocal counties of LA and Orange County. Now I believe it's all counties. So
Right.
you can transfer to Northern California, and if you're over 55, you should be able to keep the basis of the current property. But I have to tell you, Lee, that is a small little concession based upon what people are now having to do, which is to choose to sell the home because they can't afford the property taxes, as opposed to living in the property and inheriting property.
Right, but they're forced to sale if it becomes an investment property, not if they decide to live in it, right?
That's true.
So you're
Absolutely
concerned,
true.
you're concerned about people being able to retain a property and rent it out at a lower
That's
tax basis.
that's true. That's correct. I mean, most children, we want to believe that most children are older adults when your parents die and they've already owned their own primary residence. So this is not a residence that they would have to move into. And that's, just depends.
Yeah, but technically it's good for realtors if they choose
It
not to
is.
move in, then they sell it and it becomes a primary residence for someone else.
Yeah. For the real estate industry, I think it's been great. I just always think, I don't like paying taxes. That's all. So it's just more of a general, thought process. But I understand, yeah, for the real estate industry, it's been really good.
Okay, thank you.
Thank you. I think that might be it.
Any other questions, you guys? That was such great information. And again, Tracy, thanks for being such a resource and taking time to answer phone calls and questions to see if people do need to move forward and get your services or not. We really
Not a problem. And I always tell my realtors, you can always call. And I don't click it. I don't start the clock. I'm happy to answer questions and try to help. I do a lot of it. A lot of title officers call me and I'm trying to look for answers for them if I can do it. And I'm not charging. And then of course, when we get engaged, it's a different story, but I love being a service to people. So if you need something, holler back and we'll see what we can do. Okay.
You've
thank you
been
so
super
much.
helpful. Thank you so much.
You guys have a great day. Okay. Take care.
Thank you.
Thank you. I'll send her
Sure.
contact information to everyone so you have it in your email records as well.
Take care, guys.
Bye. Thank
Bye-bye.
you.
Bye-bye.